Los Angeles court interpreters, as you know, have been on strike for almost 6 weeks due to the court's failure to engage in good faith bargaining with our union.
I want to say on behalf of the Judicial Council that clearly, in order for individuals with limited English proficiency to participate fully and fairly in court proceedings, they must have the assistance of competent interpreters.
As a chief prosecutor for the city of Los Angeles, I know how indispensable our court interpreters are to the administration of justice. They provide a crucial service to all foreign language speaking parties in the justice system, including victims, witnesses, and defendants.
Unfortunately, the demand for interpreter services has grown steadily, while the number of interpreters available to meet the demand has dropped significantly.
We are going to be seeing a growing need for interpreters, and we need to be doing more and more to be able to attract people to this profession.
The ability to provide due process and equal protection to limited English speakers in the court system is dependent on expanding the pool of interpreters who are adequately trained and certified. The integrity of the judicial system depends on it.
Our legal system is predicated upon equal access to justice. If you don't have access, you don't have justice. The court interpreters are the gatekeepers.
In response to the strike, only last week I gave directions to administrative staff to begin planning for a reduced complement of interpreters court-wide permanently.
We're very concerned about the strike. It is having a very severe impact on our practice and our clients.
This crisis has led to a breakdown in the system, a very serious breakdown.
It has certainly been disruptive. It's created major inefficiencies and major inconvenience that as we move forward with our cases could perhaps result in a miscarriage of justice.
There have been statements made today, I think the facts don't support them, that there is in fact chaos in the court. We couldn't more strongly take issue with a statement that far beyond the truth.
My prosecutors are having their trial dates continued, delayed consistently because of a lack of court interpreters. As a prosecutor, I can tell you that the more a case is delayed, the greater the likelihood that witnesses will be lost, that evidence will be lost. And yet each and every day my deputies come to me with stories of judges forcing them to either delay their cases or transferring them to other jurisdictions.
Attorneys are being asked to put over cases, not just trail them within their periods, but continue them. You have cases that could be resolved in a short period of time going on for extremely lengthy periods of time.
While the past month has been an inconvenience for the court, it certainly has not brought our operations to a halt. We are proud of our response to these challenges and in the way we continue to serve all of the residents of Los Angeles County.
What the judges or bench officers are doing, they're finding good cause to continue a case over the objection of the defense.
It is unknown whether work action constitutes good cause to continue a last day preliminary hearing or trial over defendant's objection.
In People versus Augusto Cornejo, we were forced to delay by 2 months, from mid-October to late December, our hearing to compel a convicted child molester to register as a sex offender. Mr. Cornejo could move about the state freely for this 2-month period without anyone knowing about it. Mr. Cornejo could move into a house across the street from an elementary school within this 2-month period, and no one would know about it.
Each of our districts has modified its operations to address the strike and still meet the needs of all court users. For this, I am justifiably proud.
The judge made clear the delay was a result of the lack of interpreters.
Our court, in fact, has continued to operate in a professional, ethical, and a fair manner during this labor action.
In another case, a defendant who had been convicted in a domestic violence case was continually violating a court-ordered protective order to stay away from the victim. My prosecutors were seeking to send him back to jail on this probation violation, but because there was no available interpreters, the matter was delayed a week, thus subjecting the victim to further harassment.
I'm trying to give you an overview that is not rosy, and it's not dramatic, and it is not good or bad. It is exactly what I perceive.
A trial involving a defendant charged with road rage in front of a school was delayed for a month because his lawyer could not communicate with him without an interpreter.
Neither I nor any of my bench officers have violated our oath of office.
As an organization, MABA, we've been receiving many reports from our members about the due process violations, cases which have been continued. But there's one area that has been touched upon, and that is the juvenile delinquency system, where the litigants, those who are facing the charges, may be English speaking, their parents are not oftentimes. And in order to rehabilitate the juveniles, you have to bring the family in. Orders such as curfew, parenting, counseling, all those orders the parents have to understand.
We have not sat back idly. We're triaging cases. We're using other services.
Well, what's happening is that the parents are just sitting there, just like looking around, not knowing what's going on.
I want to know, as Assembly Speaker Fabian Nunez has asked, is it true that the court has possibly used unqualified substitutes for the regular interpreters?
As has been mentioned already, the ability to navigate the court system is extraordinarily complex. The English you need to know to watch TV, go to the grocery store is not at all the same as understanding a legal document or participating in a hearing, understanding your rights.
The court has provisionally qualified some 30 to 40 Spanish interpreters who are not court certified during the strike. We have received copies of emails from attorneys who complain that it is evident some of these interpreters are not competent.
We have been able to continue to do an admirable job, in my estimation, a job that I am very proud of, that we have been able to do that which you've seen.
What I see happening is that the courts are conscripting interpreters from different areas, interpreters who don't have the same qualifications that we've gotten used to over the years with court-certified interpreters.
We have sat in courtrooms and observed them at work and confirmed this, and we have documented our observations, which are all in the documents. We have watched as some of these interpreters have paused for long periods of time, and it is clear that a significant portion of the proceedings is going uninterpreted.
Will we be able to deliver first-class service instantly? No, we're not going to be able to do that.
Every case that uses someone with lesser qualifications is taking a chance on what that interpreter is going to say or how the translation or the interpretation is going to come up. I'd like to relate to you a recent case that I was involved in. It involved 4 defendants in a last day preliminary hearing case, very, very serious charges. We waited until the afternoon when they were able to find someone to come and interpret in a very serious attempted murder case. When that person took her position as an interpreter, I inquired of her whether or not she was certified. And her answer was, yes, I am certified. And subsequent to that, it was determined that the person who interpreted was an administration hearing interpreter. This was a key witness in a case where identification was a key issue. And the translation that I was getting back was completely in error.
It would be a violation of my oath were I to allow the pressures of one union to interfere with the justice which our court provides every day to everyone. It would be equally wrong for the taxpayer money to be spent inappropriately.
Can you estimate the cost to the judicial system caused by the lack of the interpreters during this job action?
I can give you just a sense of it. I think it cost per courtroom about $12,000 a day.
It has happened in several cases, many that I know of, where the witness is actually in court. The victim witness is in court, ready to be called, but there's no interpreter. In addition to all the other ramifications that Ms. Moore mentioned, the other ramification to both sides is that they're not able to assess the value of that case. They're not able to resolve it at that early stage, and what's likely to happen is that case is going to go to trial. That could be a 2 to 3 week trial. That adds cost.
I think what we are all trying to say is the real cost here cannot be estimated. The impact on these cases, on our lawyers, on what the dispositions are, on the defendants that are staying in jail longer, on the witnesses that now will not come to court because they've come and they've been inconvenienced and now will come no more. It's that intangible impact that really is affecting all of us so deeply.
we're not going to thrive. But we will compensate, and the longer this goes on, the more adjustments we will find, the more will change. I think the process is playing out the way it was intended to play out.
This has been very illuminating. I think, we talk about order in the court. It sort of seems to me that there has been disorder in the court. And probably more than anything, your testimony clarifies to me what has occurred, sort of the peak where we are. Our backs are up against the wall. The worst may yet come forward. And there's a real need for us to take a look in legislation perhaps, or perhaps court challenges, appeals with respect to what has been occurring in the last 6 weeks and what will continue to occur if we cannot settle this and get back into the courtroom. So thank you all so very much for your testimony.